Thank you, and you may all be seated. First, good evening and welcome to the championship round of the Hoffman Cup. At this point, I'd like to get started with some of our preliminary matters. First, what I'd like to do is begin with entries of appearance by our attorneys, and I'll begin with the prosecution. If I could have entries of appearance by prosecution, please.
Good evening, Your Honors, ladies and gentlemen of the jury. My name is Nicholas Tutalian.
And my name is Jonathan Copley, and we represent the people.
If I may approach with written entry of appearances.
You may.
Sir.
And then at this point, we'll go ahead and go to entries of appearance by defense.
Good evening, Your Honors, members of the jury. My name is Adrienne Jones, and I, along with my co-counsel, Lev Price, represent the defendant, James LeBron King, in this matter.
Thank you very much.
I have entries of appearance, if I may approach.
You may. Thank you. And we'll let the defense be seated. Let's go ahead and move on. First, I want to check with any of our conflicts checks. Do any of our scoring judges know either of the teams to a degree that you think it would affect your ability to provide an unbiased evaluation?
No.
In that case, let's go ahead and move on to some of our preliminary matters. I'll move to motions and limine in just a moment. But first, I'm going to begin with the prosecution. Do you have any housekeeping or pretrial matters?
Yes, Your Honor, we have two housekeeping motions this morning. First, pursuant to Rule 615, we ask that all non-essential witnesses be sequestered, except for Detective Wardinsky, who will be serving as an advisory witness through these proceedings.
Any objection to the request for sequestration?
We have no objection, Your Honor, so long as Mr. King can also be present.
The prosecution needs the detective as an advisory witness, and the defendant certainly is an exception as well as sequestration, but sequestration is otherwise ordered. Any other preliminary matters?
We also ask for permission to move about the well.
Within a reasonable distance, and what I mean by that is I'd like to have you keep within about an arm's length of the podium, and maybe no more than about 2 or 3 feet closer to the bench. But other than that, you do have liberty to move about the well.
Sure.
Any other preliminary matters?
Not from the people.
All right. Any preliminary matters by the defense?
Yes, Your Honor, the defense has 2 preliminary matters. The first is for the substantive stipulations to be constructively read into the record.
All right. That's granted.
And the second is for the jury instructions to be constructively read to the jury prior to closing arguments.
I'll grant that as well.
That concludes the preliminary matters for the defense.
All right. Let me first just check, and I've skipped a step, but is the prosecution ready to proceed to trial?
Yes, Your Honor, the people are ready to proceed.
Is the defense ready to proceed?
Yes, Your Honor.
What I'd like to do is, before we move to the motions in limine, if I could have all of our counsel and witnesses and members of our gallery please stand and raise your right hands. Do all of you swear to abide by the rules of this tournament and conduct yourself in a manner that is honorable to this forum and to this tournament?
I do.
Thank you. You may all be seated. Let's begin then with motions in limine, and we'll begin with the prosecution. The prosecution's motions in limine.
Yes, Your Honor, the prosecution has 2 substantive motions in limine. To put these motions in context, this case is about 2 friends who had a falling out. In the early morning hours of June 26, 2011, these 2 friends struggled for possession of a .45 caliber pistol. The defendant ultimately won that struggle, and he used that pistol to execute his friend with a single shot to the back of the head. With that context in mind, our first motion in limine deals with the actual murder weapon in this case. We anticipate the defense will claim that this was an accident, and in furtherance of that, we anticipate they will attempt to bring in the manufacturer's specifications regarding the trigger pressure. By that I mean the pressure required to pull the trigger. Pursuant to Federal Rules of Evidence 801 and 802, this is hearsay, and we move to exclude it at this time.
Any response by the defense?
Yes, Your Honor. The defense does intend to introduce this information. Under Federal Rules of Evidence 803.17, this is a commercial publication. The manufacturer's literature is the basis for the pressure listed, the amount of pressure needed to fire the gun. Under 803.17, if the information is regularly relied upon by persons in a particular field, it may be admitted. In this case, Detective Warinsky is a firearms instructor. They regularly rely on manufacturer specifications as to pressure.
And then you reply.
Your Honor, I would stand on my original objection. I don't actually believe, or the trigger pressure specifications do not meet that exception. And further, I'm not certain counsel can lay the proper foundation that this specification itself is the type of specification that is typically relied upon by an officer such as Warinsky.
What I'm going to find at this point is I'm going to sustain at least and overrule the exception under 803.17 that generally applies to market reports and compilations. I think the operative word is it is a compilation such as stock reports or the types of things that are relied upon. Otherwise, it would expand and include all manufacturers' specifications. So is there an additional or a separate exception that defense thinks apply?
Yes, Your Honor. 807, the residual exception, also applies. To that end, there is no question as to trustworthiness. Detective Warinsky has testified to this information on behalf of the prosecution in the past. It does represent a material fact. The defense does contend that the shooting was accidental, and therefore the amount of pressure, specifically that the pressure required on this gun was below manufacturer specifications, is a material fact. The information is more probative to the question of the trigger pressure than any other information available. And finally, admitting this information does serve the interest of justice to find the truth of the matter. As the defendant does claim it was an accidental firing, the pressure on the trigger is very material to that.
Let me come back. Your reply in terms of the residual exception under 807.
Yes, Your Honor. Regarding exception 807, or Federal Rule of Evidence 807, specifically A1, I don't believe the manufacturer's specifications have a statement that has equivalent circumstantial guarantees of trustworthiness, and I don't believe that the manufacturer's specifications meet this exception.
And at this point, I just want to clarify with counsel, we're talking simply the manufacturer specifications at this time. Is that correct?
That's correct, Your Honor. It is the manufacturer's specification for the standard triggerable pressure for the weapon in this case.
Admittedly, the residual exception is rarely used. It's not something that comes up very often, and oftentimes, traditionally, most courts require advance notice and hearings, and not so much as a pretrial matter, but I understand that we don't have the ability to have pretrial motions hearings on that issue. What I'm going to find is that to a certain degree, the manufacturer specifications are similar to a business records exception in terms of the fact that there is a circumstantial guarantee of trustworthiness in that it is to the benefit of a business to be accurate in terms of what they report. There's interest aside from trial work that would allow a manufacturer or encourage a manufacturer to try to make sure that the information is accurate and verifiable in that it may bind them in terms of liability in that regard. It is a creative argument. Although I had rejected the 803.17 argument, I will, under these circumstances, overrule the objection in the motion limiting and allow this under the